So, so what I do is with the videos is that we create a YouTube video on it and then also send it out to everyone in our database just as an informational piece to kind of help everybody out. And I thought Tim would have some awesome information about now that we purchase our home, and other things is how do we protect our assets? And I thought Tim would be perfect for that. He's an attorney specializing in real estate and some other things. He'll tell you a little bit more about himself. But he's an absolute amazing attorney. I've known him for probably going on 6-7 years at least. He does my own stuff as well as I've referred him a lot of our clients. It's really enjoyed his services. So without further ado, I'd like to introduce Tim. Thank you, Tim, for coming on tonight.
Thanks for having me, Jim. Thanks for the very kind words there. I am an attorney. I've been at it for about 25 years. My office is in Waterford, kind of on the Clarkston-Waterford border. I handle a lot of real estate related matters, probate, estate planning, trust wills, all of that type of stuff. I do have feet planted pretty firmly in the real estate and estate planning world, which many attorneys don't. They tend to stick to one lane or the other, which I find is very helpful for my clients when it comes to something like what we're about to talk about, which is trusts and protecting the assets. My approach tends to be a little bit more informal. No need to be high pressure at any point in time, but certainly not tonight. If you're Jim's client, then that tells me what I need to know as far as you're generally good people and you don't want a hard sell or a lot of pressure on anything. And so what I thought I'd do tonight is just kind of walk through kind of a general overview of what might be good for you and give you some stuff to think about, hopefully, if you don't already have an estate plan in place. Estate plans tend to be very, very specific to the individual, to the family. And I'm going to speak a lot in family, in terms of family, but if you're a single owner of the home, this very much applies to you as well. A lot of times I'll get phone calls and people say, well, I need a will, or I need a trust, or I need this, or I read on the internet that this is good. Or I had a friend that told me, or I had a parent that told me I needed to come and get this. And so how much is that going to cost? And when can we get this done? And a lot of times it's, well, let's pump the brakes a little bit. Thank you for starting to plan. A lot of people like the idea of doing some estate planning to try to protect themselves, their interests, but they don't like to cross over and make that step of setting up a plan. It's either, well, I don't have time for it, or my spouse or significant other, we're not on the same page right now, and there's too much thinking, or it's going to be too expensive, or I just don't like to think about the possibility that I'm going to die, or that my spouse or significant other is going to die. And if I don't think about it, then it's not going to happen. And that's probably not the best approach to take. So like I said, my goal tonight is to kind of put out some information. Hopefully it'll be helpful. And if you have any questions, feel free to, I know there's a raise your hand on here, or just unmute yourself and say, hey, I've got some questions. This isn't just supposed to be about me talking. If you've got some questions, that's jump right in and we can address that. As far as our home purchase, and it doesn't matter if it's your first home and you've been in it for a couple weeks, or if it's your fourth or fifth home and you've had it for many, many years, it's important to protect it. Usually these are our biggest assets, our most significant assets for many people. And whatever the value is on that, it's yours. People say, well, I got a mortgage on it. No, this is your home. It may be subject to a mortgage, but it's your home at the end of the day. And without an estate plan that is going to anticipate a transfer of the property after you've left us. And again, this is a lot of times it's, oh, this is so morbid. You're killing us off. You know, we don't want to die. No, I don't want you to die either. But unfortunately, the world we live in, and every week it seems that there is yet another catastrophic situation out there where people lose their lives unexpectedly. And that's kind of what estate planning is really geared towards. It's not necessarily just you passing away. It's the catastrophic of, if you're the only homeowner, if you're the only one entitled, then you're already working without a net if you don't have something in place, because you're going to end up going through the probate process. I'm going to talk about that a little bit more here in just a second, but even if you do have a spouse and you're both in title, or a significant other, or a sibling or a parent that you co-own the property with, usually when we're in that type of relationship where we're comfortable enough having them own the property with us, we do things like travel, go out to dinner with them in the car with us, go grocery shopping, take trips, go out for ice cream, as it sounds like the Turners are doing a little bit later on tonight. And if we're in an accident, there's a likelihood that one or both of us might go. And it's that type of catastrophic scenario that we want to plan for. In the event that one or both of us are gone, do we have small children, young children? We certainly don't want to leave them out there with our biggest asset. Do we have maybe an older child that might have some special needs? Do we have a situation where, yep, if we go, what's going to happen to it? Well, it's probably going to go to my brother or your sister, or we're going to leave it to our parents. Do these parents or the sibling, whoever it is, is there possibly an issue there? Is there maybe a gambling situation where if we leave them the money, it's going to result in one heck of a weekend in Las Vegas, but not much more beyond that? Is there an addiction where if we leave this home to somebody directly, is it going to get sold? And if, this person gets 150,000, 250,000, 350,000, 450,000, is the money going to result in drugs, which is going to terminate their life? Is it a situation where maybe we have the person who's going to get it that they're in a bad relationship? They make bad choices with whoever their significant other is, and that person might come in and take the money. Is it a situation where the person you leave the house to, are they just bad with money? And I hear this frequently, where I love my son, but he's terrible with money. I love my daughter, but she's a spendaholic. And if I die and we just give them the house, they're going to sell it, and the money is going to be gone in a pretty short period of time. So these are all specific things that factor into what is your plan? What is the best thing for you? Because we have a lot of tools in the toolkit that allow us to tailor whatever you have and whatever your biggest concerns are about protecting your home in the event of this catastrophic situation, that we say, okay, well, this is probably the best thing, or maybe we should do this with it. And there's plenty of attorneys out there. You call them up and say, I want to trust, and they'll say, all right, I'll do that for you. They don't care about your situation, and they're happy to sell you a binder that's this thick that by the time you try to read it, you reach page 3 and your eyes start to bleed from the legalese. And they're going to charge you a whole lot of money for that. And it may not fit your situation. Again, it's not uncommon for me to get a call that says, hey, we have a trust in place, but it's been 10 years. We had a change in circumstance and we'd like to update it. And I said, well, okay, well, what's in there? I don't know. I've never looked at it. We just paid the attorney and he said we were all set. That's probably not the best way to approach this. This is your plan. You should understand exactly how it works and know that what is in place is what you want. So when it comes time for, we have had a family change, whether or not it's some minor children that are now adults and they've, they're 18, they're 21, they're 23, and what you had in place was for when they were 8, 9, 10 years old. Maybe there's been a divorce, maybe somebody's passed. There's a lot of reasons why we might want to say, okay, let's update it. But at the end of the day, it's important that you know what is in place for you. And none of these documents, a will, a trust, they shouldn't be intimidating because of the legalese that's attached to them. You should understand them. You should know what's in there. There's no reason for us to have, there's very little reason for us to have a 75-page trust or a 50-page will. It just needs to say what it is that you want it to, because if you don't know what's in these documents and you leave us, how's the person who's coming in to take over, the one that's responsible for dispersing the assets, gathering your assets, putting into place your wishes, how are they ever going to understand that if you don't even know what's in there? So that's kind of our starting point for what is it that you need, what is it that you want. And my biggest takeaway for you on this is there's no one size fits all. It all depends really on what is it that you want. And a lot of times people will say, well, I think a trust is this, or I think a will is that, or I have a will, so I'm all set. Or why would I want to trust? Trust is when I was young, many years ago, it used to be, well, the only people that have trusts are rich people. And well, we're not rich, so why would we ever have a trust? It's not about wealth, it's about circumstance. And trusts don't need to be this overwhelmingly complicated document that's out there that needs to cost thousands of dollars. A will doesn't need to be an overwhelmingly complicated document that costs thousands of dollars. And it really comes down to, like I said, what is it you want to do? Who are we protecting? And in certain circumstances, a trust is a fantastic document to provide that protection. There's other documents out there. There's a thing called a ladybird deed. There are deeds where we can add a joint owner on there with us if we're the sole owner of the property. We see this a lot with parents where they're starting to get a little bit older and one is passed. Well, we don't want the house to go through probate. Maybe we add on a brother and a sister into title with mom. So let me spend just a second to get into the what is probate and why is probate somewhat of a dirty word. The probate process is required when a person dies and title is held solely in their name to real property or to bank accounts. Items that require a legal owner to transfer it is what we're looking to protect. And our two most common reasons why we have to go through the probate process are somebody dies with a home titled solely in their name. We have bank accounts solely in their name. And many times this is, well, mom and dad own the house and dad died. We intended to do something, but mom left us unexpectedly, or we couldn't get mom in to see somebody. So now we're going through the probate process. It's the legal process by which we distribute somebody's possessions, somebody's assets. And if we have a will, the will is a legal expression of our wishes regarding our assets. If we have that, then that is kind of the document that is going to determine who gets what. A will is a good start. A will is a valuable document because it allows you to say, this is who I want to receive my things. What a will does not do, however, is transfer real property or transfer bank accounts to whoever it is that we've designated as our beneficiary. And that's one of the big misconceptions out there, is that people say, well, I have a will, so I'm all set. I don't need to do anything. No, you're set with telling people who's going to get what, and hopefully avoiding family drama, but it doesn't prevent the probate process. And it also doesn't allow you to transfer that property. In Michigan, there are two ways that we can transfer real property. One is by a deed, and the other is by a court order. If a person dies having only a will, they're not around to sign the deed. So then we have to get the court order. And the court order comes in the form of what's issued by the probate court, a letter of authority, appointing a personal representative. Probate can take anywhere from 6 months up, depending on how complicated things are. And if a person dies and they don't have a will, then the state of Michigan determines what's going to happen to your stuff. And that's called intestate succession. There is a statute, there's a law that says this is who's going to get your stuff. And sometimes that's fine, where you say, all right, yep, I want my wife to get it. I want my husband to get my stuff, or I want my children to get my stuff once I'm gone. Well, maybe we don't. Maybe we don't want all 3 children to split your stuff equally. Maybe one of the children is no longer in good graces, and we really don't want that person to have stuff. There's other reasons as well. Like I said earlier, we might love this child, but they might have a spending problem. They might have a gambling problem. They might have a bad relationship problem. And so from the starting point of a will, great idea, because it allows you to say, this is where my stuff is going to go. But wills are for probate. And if we have a good estate plan in place, we get to avoid probate, and the will sort of becomes superfluous. It becomes this document that is really just our safety net in the event that, oh, I forgot that I had that bank account and there's money in there. Okay, we're going through there, but this is going to say who gets that stuff. In order to avoid probate and the cost associated with it, because while you can handle probate on your own, it is complicated, and the courts aren't always very helpful in giving you guidance. In fact, legally, the clerk behind the counter is not supposed to give you guidance, and they have a big sign up that says we are prohibited by law from giving legal advice. So if you go in and you fill out the stack of forms and say, I'm here to open up a probate estate, if you're wrong, depending on who's behind the counter, you might not get the answer as far as what do I need to do. Attorneys, when it comes to probate, aren't always very cheap. So now money that should be going to heirs is going to the attorney. It's certainly going to the probate court because you're paying a filing fee. It's going to the legal news because you're paying a publication fee to notify creditors of a death. It's going to the probate court for an inventory fee. So these are hundreds, and in some situations, thousands of dollars that are being pulled out of the estate, meaning going to your beneficiaries, or you, if you're the beneficiary, that probably could have been avoided had just a little bit of advanced planning been done. So when it comes to what are our options on this, one of the options, like I said earlier, is the trust, where we put our property into this entity called a trust. And it's probably a good idea if I start to define some terms so that everybody understands what we're dealing with here. A trust is the legal document that is our playbook. It's an expression, a legal expression of our wishes, where we get to say, this is what's going to happen with this. It's not great for every circumstance, for every situation, but it is for certain circumstances. I'm going to focus on just I have minor children. If I have minor children, whether or not they're 6 months old or 17 years old, they're minors. And what we don't want is, in that catastrophic situation where we leave these surviving children, to just have this big lump of money that represents our home, the value of our home. And it's somewhat crass to just monetize what your home is. I love my home, and it doesn't sit well with me to think of it as just this pile of money. But in a sense, that's what we're doing, is we are monetizing what our assets are as part of the estate plan and saying, this is who I want to have get this and this and this. And if there are these certain circumstances, minor children, special needs children, we're trying to protect our beneficiary from whatever it is. The trust provides this playbook where it controls, you're basically controlling from the great beyond, who is going to get what, when, where, how much, how often. And that's sometimes a really important factor in our lives. It gives us a little bit of confidence that if something does happen to us, that I know my minor children are going to be provided for. My special needs child is going to be provided for. My sister, who is getting my stuff, but has bad issues going on in her life, I don't have to worry that all of my equity in my home, everything that I've worked for, is going to go to her creditors. And that can insulate and protect somebody that needs that is going to be your beneficiary. And so let me go back and define some words here. The trust is the legal document. The settlor is just a fancy way of saying the creator of the trust. The trustee is the person who is responsible for managing, for overseeing the trust. There's a fiduciary obligation, which means that legally you have to act in the best interest of the beneficiaries. The settlor is typically, the creator of the trust, is typically the initial trustee. And the most common type of trust out there is the revocable trust. There's many other types. I'm going to stick just to the revocable trust today. The revocable trust, where the trustee is the creator, is the settlor. As long as you're alive, you get to do anything you want with your trust. Your property's in there, you can sell it, you can rent it, you can mortgage it, you can burn it down. It is entirely yours. You can put it into the trust, you can pull it out of the trust. Your money is yours. But once you die, the trust becomes irrevocable, which means it's locked into place. At that point, we then have the successor trustee. The successor trustee is the person who really has to do the heavy lifting. They're the ones that have to come in, understand what it is that is in your trust. What's the playbook tell me? Sometimes it's pretty simple. I want you to take the money, sell my house, take my bank accounts, put it all in one account and invest it. Make sure that hopefully it continues to grow and it's for the benefit. The beneficiaries are the people who are going to receive your gifts in the trust. You're looking out for what is the beneficiary going to get, when, where, how. And sometimes it's just, I want you to distribute 50% to this person, 25% to this person now, hold back the other 25%, and in 3 years, give that to them. And the reason is, well, the person that's getting the 25%, they're 23 years old, they just graduated from college. Let's give them some money to go out in the world, maybe do some business, possibly fail. And if they do, take some risk, go live. Because then in 3 years, after you've had this experience in life, we're going to give you some more money so that you can pick yourself back up if you failed, or maybe, hopefully, you don't need it because you've already succeeded. So that would be an example of it. It can also get a little bit more complicated depending on, well, I have these children, and how much do you want to micromanage from the grave? I've done trusts where with younger children, the parents have decided we have their lives planned out for them. And my daughter is going to be in theater. And so I want her to take trips to New York City to go to Broadway. And my son is going to be in sports. And so there's going to be all these sports camp. And so my successor trustee needs to plan out and manage the money so that that happens. The problem with that is that things don't always go the way that we might think they're going to go with our younger children. And when our daughter is 8, she's a completely different person than when she's going to be 15 or 16. And what she's into at 8, when you know her, may not be what she's into at 15 or 16 after you've been gone for a few years. So there's positives and negatives about how we handle these types of things. That's one way to do it. The other end of the spectrum is we give pretty much carte blanche authority to whoever our successor trustee is. And we say, take the money, invest it, and just give them a good life. And sometimes that works out with who we choose, and sometimes we don't choose the right person for that. So again, there's a lot of things that factor into who we're going to pick to be a successor trustee. Is this person good with money? Are they going to have to hire somebody that's going to give them advice? Do we trust them? Because while this is a legally enforceable document, at the most simple level, it's relatively unsupervised. Unless you have family members that are looking out for the children's interest, there is definitely a possibility for abuse when it comes to whoever your successor trustee is, and we're giving out this carte blanche authority for health, education, welfare. That's a negative that comes with that. So like I said, positives, negatives, when we have these things, it's important when you make this step, when you talk to an estate planning attorney, that you have these conversations. And many times, like I said, I get the phone call, we want to do this. Well, let's talk through this to find out what is going to be the best thing for you. Part of the estate planning attorney's role is to listen, to hear what you're saying as well as what you're not saying, and to ask these questions. Typically, when I have my meetings, there's going to be a couple. The first meeting, I usually set aside about 90 minutes to sit down, listen, and then I start to float some scenarios and I ask some questions. And it's pretty typical that my client leaves with homework assignment, especially if it's a spouse situation where we need to talk about this. If there's young children, if there's special needs, if there is a family member that we're concerned about, what are we going to do here? Who is going to be responsible? Who do we pick to maybe be our successor trustee in the catastrophic situation where we both leave? Again, the base layer where we have spouses and, all right, the trust is ours. Something happens to me, you've got it. It's revocable. During your life, you get to do anything. That's the easy part. That's not what we're preparing for. We're preparing for runs to the ice cream store and something bad might happen. We're leaving a family, we're leaving siblings, we're leaving a parent that might not be in the best situation financially. There might be Medicaid concerns. So if we leave mom, our house, what's that going to do to her eligibility there? These are all things that need to be kind of discussed. And for me, I rarely get into amounts, figures, what's in the bank account, because to me, it doesn't really matter if there's $100 in there, if there's $100 million in there. $100 million, it does change things because of the estate tax that's involved. But for the most part, your estate plan should be yours. It should put into place what it is that you want. And to have that conversation, sometimes these are hard conversations to have at home, and people don't like to cross into that. But the alternative is, and unfortunately I've seen a lot of this with my probate clients, had mom just done this, had we just done this, had I forced the situation and taken her in, we wouldn't be going through this probate process, because my brother who lives in New Mexico and we haven't seen in 18 years and doesn't communicate with us has now suddenly shown up, gone into the house and started taking stuff. And because he's the oldest brother, my two sisters aren't any help. And they just, well, that's how it goes. And assets that maybe mom wanted to go to the grandchildren might not be around anymore. So there's all these different scenarios that may apply to you, may not apply to you, but these are things that I have run across, and it's it's not pleasant for me to sit there during the probate process and have a family say, gosh, I wish we would have just done this. It would have been so much easier, so much cheaper. Emotionally, we're so drained by this. And just the worst example that I've had in my 25 years in the probate, mom passed away. She was in her 80s, two adult sisters in their late 60s, people who you would think should have known better, relatively successful adults. And mom had a salt and pepper shaker collection that she had accumulated over the years. And one sister in particular had given her many of those salt and pepper shakers. You probably have gone down to the Dixie flea market there at Telegraph and Dixie and purchased 3 times as many of these salt and pepper shakers for probably about $25. But so the actual value of them was pretty small. The problem is the emotional value that was attached to it was invaluable. And the two sisters would not give on that collection. I want it. No, I want it. Mom didn't leave a will. Mom probably didn't even know that this was going to be an item, because I'm sure that she would have taken care of it. The sisters spent 18 months and thousands of dollars fighting each other over this salt and pepper shaker collection, which had an actual value of dollars. As far as I know, they have terminated their relationship over this. And it's one of those things where it's heartbreaking in a sense, because a little bit of advanced planning probably would have allowed one of them to be able to come in and say, this is how it's going to go, right, mom? And have mom clarify the situation. It didn't happen. And she didn't have a big estate to begin with. And many of those assets ended up being spent on the contentiousness between these two people. So it's kind of an example of where things can possibly go if you just say, I'm gonna ride it out. I'm gonna play it by ear. But back to the house, a trust may be good for you. A trust may not be good for you. I try to listen. I try to put you in the best vehicle for you that's going to accomplish what you want. And if that means that you walk out spending a couple $100, then that's what you needed. And if you walk out with this complicated trust, then that's what you needed, because that's how I operate. There's other attorneys out there, like I said at the beginning, that are happy to just take your money and give you this thing and send you on your way. But it's important that you have a comfort level with who you work with. And it shouldn't always just be, oh, this is the cheapest attorney that I could find to do this for me, so that's where I'm going to go. It's no different with your dentist, with your doctor, with your florist, with whoever it is. You should have this comfort level of working with this person where it's, yeah, I feel like we're doing the right thing here. I trust this person. So I've been talking now for well over half an hour. Nobody's interrupted me. I'm gonna now force the issue, I guess, and say, does anybody have any questions about anything I've talked about? Does anybody have anything that they would like for me to get into? Mr. Kraus.
Hi. Yes, Tim, I have a question. In a trust, is there a lot of fees to maintain it as you go along, or how does that work?
It all depends on the type of trust that we set up. It depends on who our trustee is. I said earlier that typically the settlor, the creator of the trust, is the initial trustee. If that's the situation, you're not incurring any fees because you're the one that's managing this. Where we start to see fees is if we have a corporate entity that comes in, a bank, a trust department in a bank. They are going to charge, and the bigger the bank, the more fees that are going to be out there. Commonly, their fee is tied to what's the net value of the trust, of the assets in the trust. And so the larger your assets in the trust, the more money you're going to spend. I generally don't like the idea of naming a corporate trust. To me, that should be way down the list unless there is a specific reason why we're doing that. Now, sometimes people say, I don't have any family. It's me, but I want my home to go to my niece or my nephew, but they're out of state. They're not around here. I don't want to burden them with that. In that type of situation, I've said, okay, yep, let's talk about some of these corporate entities that are out there that can do that.
Yeah, and you could probably in advance move stuff around to avoid that, correct? While you're alive.
Yes, yes. There's a lot that I haven't gotten into with our various options for estate planning. Jim had said, let's focus on the house and let's focus on trusts and protecting it that way. There are many ways out there that we can do an estate plan that accomplishes most of what we want at a relatively small amount of money. And Jim, if you'll indulge me for just a minute, I promise.
Yep, sure.
Quick here on this. With
You're fine.
stuff, we can typically place our lives into, not to oversimplify it, into three categories, three buckets of things. First bucket is our real property, our homes, if we have rental properties, if we have cottages up north, whatever that whatever it is, our real property is our bucket number one. Our bucket number two is our financial accounts, checking accounts, savings accounts, IRAs, CDs, life insurance policies. Anything that falls into the financial area is bucket number two. And then bucket number three is typically our stuff, our personal belongings, our furniture, any collections we might have. And the collections, bucket number three, can be dealt with through a will by saying, this is who I want to have my stuff. Communication I'm a big fan of communicating, although I understand families typically fall in between two spectrums. One spectrum is when I die, they'll find out what I had and what they get. And then the other end of the spectrum is everybody knows what everybody else is getting there. Bucket number two can be dealt with through designated beneficiaries. And again, our two most common reasons why we have to go through the probate process, even with a will, is that bank accounts remain titled in the decedent's name, real property remains titled in the decedent's name. With our financial accounts, we can use the designated beneficiary, which is very similar to the life insurance policy. Life insurance policy, we name who it is that we want to get this. You can go into your bank, you have a checkings and savings account, and ask the bank to allow you to identify a designated beneficiary or beneficiaries. You're not adding them as a co-owner, a co-signer. It's only upon your death. Banks call it payable on death, POD, or transfer on death, TOD. Different banks have different phrases for it, but the concept is the same as the life insurance policy. If I die, I want this person to be able to come in with their driver's license and my death certificate and say, give me my money. We avoid probate that way. And CDs, many of our financial accounts already allow us to designate those beneficiaries. And it's the same thing. It takes a couple minutes to go into the bank and to do that. And by doing that yourself, spending those few minutes, you've already handled one of the biggest areas that's a problem, your financial accounts. Our first area, our first bucket, the land, what we want is there to be a legal connection. And much like the designated beneficiary, we don't necessarily have to add somebody on as a co-owner. In fact, many times there are more than enough reasons not to add somebody on as a co-owner in the event of our, single owner or joint owners catastrophic situation where both co-owners die at the same time or within a relatively short period of time. The trust is a mechanism, a tool in our toolkit. The Ladybird deed is another one, and I mentioned that at the very top. Again, very briefly, a Ladybird deed allows us to retain ownership for our life. As long as we own this property, it's completely ours. We can do anything we want with it during our life, and our designated beneficiary doesn't have any present claim to it. We call that a contingent interest. And it only becomes a vested interest if we die owning that property. At that point in time, the property, meaning our death, the property automatically passes to whoever it is that we've designated in that deed outside of the probate process. So just in the last couple minutes here, I've walked you through really what my estate planning process, the conversation, a big part of it is our real property. What's the best mechanism for you on that? Do we need to have a playbook in place to protect our beneficiaries, or do we just say, no, it's going to go to my son and his wife, or my 2 children, or my cousins over here, and we're going to give them title? Maybe one of them is going to buy out the other one. Maybe they're going to sell it and split it, and maybe they'll go to Vegas and have a hell of a weekend, and that's what I want, type of thing. So we've taken care of bucket 1. Go to the bank. Make sure that whatever financial accounts you have that designated beneficiary on there. You will have taken care of bucket number 2. Bucket number 3, communicate. And if you think that there's likely to be a dispute over your personal stuff, do the will, do a simple will. It doesn't need to be super expensive. Now, there is a 4th bucket, and that's business interests, but that's kind of outside the scope of what I'm talking about right now. So I hope I answered your question. If I didn't, please kick me and say, no, I need to know more about this.
Hi, this is Heidi. I have a quick question. So if we have a trust set up that has our home in it, along with our financial interests, would that, upon, like, say, both of our deaths, if we have it going, say, to our children, would they still have to go to probate in order to sell the home, or would the home automatically go to them if it's
Okay. Yep. So with the, when I started this earlier, I said, I've got my feet planted firmly in the real estate and in the estate planning realm, but not all attorneys do. Many estate planning attorneys out there will hand you this binder that's very pretty and very thick, and that is cost a bit of money. And they'll say, here you are, you're all set. The problem is, because they don't do real estate, they haven't actually funded your trust. It's not enough. When we set up a trust, there's 2 parts to it. One is to create this playbook that meets your expectations. This is what I want. This is okay. Yep. This is what we're going to prepare. The second part, and it's part 1B really, is to fund the trust. Otherwise, think of the trust as a box, and we've set up this box. Without funding it, it's an empty box. And a lot of times people will come in and will say, yep, we're all set. No, 10 years ago, you set up this trust and you thought you were all set, but your attorney didn't fund it, meaning didn't do a deed from you to your trust. Because when I said earlier, there's 2 ways that we transfer real property in Michigan. One is by a deed, one is by a court order. A will doesn't do it. A trust itself doesn't do it. We have to have that second document that funds the trust. Assuming that your trust is appropriately funded, meaning the house is in the trust, owned by the trust, then you avoid the probate process. And moving forward, whoever the successor trustee is will be responsible for implementing your playbook with that asset for your children's benefit, or whoever your beneficiaries are, whether or not that's selling the home, liquidating it, or keeping the house and allowing them to stay there if they're adult children, making sure the mortgage is paid if there is one, making sure utilities are paid if the kids aren't sufficiently responsible to do that themselves, as an example. As far as your bank accounts, I don't like the idea, generally speaking, of putting your bank accounts into the trust name. I don't see any reason for it whatsoever. It's your money. No need to cut a check from an account that says the trust of. If you do what I had suggested, Mr. Kraus, earlier, and that's just go and add those designated beneficiaries onto your checking accounts, you're already taking care of that. And one of the designated beneficiary options that you have is to add your trust on there. So that money can go right into your trust upon your death. So that's kind of the best answer that I can give you as far as, is everything going to be taken care of if we have the trust? Yes, if we've properly set things up and funded the trust.
Thank you, Tim. And I have one last question real quick. So if we have an elderly parent that doesn't have much in the way of financial, but they do have a home with equity in it, would it be like best, it just sounds like a big trust wouldn't really be the way to go, but what would be the best way? Again, without, like, if we're put on the deed with that parent and say they like fall behind in taxes or whatever, we're kind of making ourselves vulnerable and also liable for that.
You are a co-owner if they add you onto a deed into title
Yeah.
with them.
Okay.
So the answer, and I'm not trying to give you a lawyer answer here with the waffling or anything, but the qualifications are important here. It depends on what is going on in mom's life. Is Medicaid a possibility? Because we have to be aware of that aspect of things. If that's not a concern for us, and by that I mean, do we have to dissipate the assets? And there is a 5-year look back that comes into play. So if we just transfer the property, that's a potential issue. The Lady Bird deed, again, just talking generally from a 33,000 foot perspective to give you an answer on this, the Lady Bird deed may be the best option. Lady Bird deeds are good for Medicaid issues. And it keeps you out of title, but it gives that safety net where if something were to happen unexpectedly, too quickly to mom, that we avoid the probate process by having her sign this Lady Bird deed that designates the beneficiaries, whoever that's going to be, and then they become the owner of the property after she passes.
Great. Thank you, Tim. Appreciate it.
It still avoids probate, which is pretty awesome too.
Yes.
So let me ask you a question, Tim. So what if you don't place any beneficiaries in all of your accounts, but you have in your will, not an estate planning, but let's say you have in your will that a person gets benefits of those accounts. Do those still apply in the state of Michigan? Is that still legal?
It's a legally binding document to the extent of whoever you have given those things to, somebody else can't come in and take them. And I'm going to answer your question, and I'm not trying to be snarky on this, but here's the example that I'm going to lay out there, and I think you're going to say, oh, if you walked into, so Jim, I'm going to pick on you, and I'm going to kill one of your parents. Your parent has a will that says Jim gets everything that's in my Chase bank account. And then they pass, and you walk into Chase and you say, I'm here to get my money. Here's the will. Here's the death certificate. Give me my money. Chase Bank is going to say, get the heck out of here before we call security on you. It's not your money until you show up with an opened probate estate. And it's the personal representative armed with a letter of authority from the probate court that says, this is who is authorized to act on behalf of the estate. So the answer is, legally, you might be entitled to it, but you are never going to get that money out of the bank unless and until the probate estate is open.
So it's very important to have an estate plan that maps that out, and or have the beneficiaries all set within each of the accounts.
Yes, it would be no different than if you, in your will, you said, I want my home to go to Heidi. And we have a situation where you don't add her into title and you die. She can't go to the Register of Deeds and say, hey, he left it to me in the will. They're going to say, get out of here.
Yeah, because it's real
This
property.
is not how we transfer assets in the state of Michigan.
Yeah. And on the flip side too, just so everybody knows too, and I know Tim knows this, is that when you transfer your deed of your home into your trust, and then you sell the home, the proceeds go to that trust, not to your name, just so you know. So you have to actually open a bank account in the name of the trust in order to deposit it from that trust because it's in the trust of the deed too.
That is true. That is true. And it does happen where a house is sold in the name of the trust and the seller is surprised when the title company hands them a check that's payable to the blah, blah, blah living trust or revocable trust or family trust. The way around that though is to, if you know you're going to sell the house or we have a closing that's coming up, we just deed it out of the trust back to you individually. And then that check is going to be in your own name. And I know that Mr. Galvez is on here, and I'm not trying to pick on everyone's favorite loan officer, but loan officers do not generally like financing or refinancing property that's in the name of the trust. And so it's not uncommon if we are going to do a refi to do a deed transferring the property out of trust into our names individually, complete the refi, and then deed it right back into the trust once that's been completed.
Yeah.
So there are mechanisms that we can avoid that, but that is a surprise that does come up sometimes when people say, and also that also can happen in a probate estate if you're selling a decedent's home, that the check that the title company hands you is in the name of the estate of, which means a bank account also has to be opened up in order to cash that check.
Tim, is it possible to have 2 or more individuals on a Ladybird deed?
Yes.
Mhm.
Okay.
The question the follow-up question on that I always need to know is, how do we want these 2 people or 3 people or whoever it's going to be to hold title? And without getting too far into the weeds on this, it can either be as a tenant in common or a joint tenant with right of survivorship. The difference is if something were to happen to one of those 2, what do we want to have happen to their interest? Do we want it to go to the survivor, or do we want it to go to the decedent's heirs? But again, that's starting to complicate things right now. The answer to your question is yes, we can't have more on a deed.
Okay. Thank you.
Thing I like about at least Tim's process, the reason why I asked him to come on, but because I'm also a customer of his or a client of his. And the one thing I do and did like about it is it's true. You do go home with homework and some aha moments that you didn't, think. I thought I was just going to walk into his office and walk out with it all complete. And it wound up being a little bit of a process. I think it took 30 to 60 days, whatever it was, by the time I started to the time it got finished, because of all the questions that I didn't have answers to. So I thought, it was a pretty good process. And then he sent me home a bunch of questionnaire of different things I needed to answer to help determine, is an estate plan perfect for me, or should I go with a Ladybird deed with a will? What is the combination? And I know we didn't get a chance to talk about it because it's not so much protecting our assets, but kind of protecting us was power of attorney. And that's another whole, set of conversation too. But when you, at least for me, and something I can just share with everybody, is that you also want to have a power of attorney in place, and what that looks like too, in case something was to happen and you wind up in the hospital, and who wants to deal with it. And I can tell you at first, like even my own kids, they were like, Dad, we don't want to talk about this. And I'm like, well, yeah, we need to talk about this because, it makes it a lot easier if, God forbid, something was to happen to me, and it'll make it a lot easier. And I just want to make sure you guys fully understand, what's going on with me, what happens, like in the power of attorney, who wants to do it, why I'm having it done. And I just want to make sure it's comfortable. And at the end of the day, when I have this nice portfolio and I went over it in advance with people, now I feel a sense of peace knowing that if, God forbid, something was to happen to me, I know that nobody has to struggle or be upset with what's going on. I feel pretty comfortable with the way I set up my plan, whereas I know no one will be upset of fighting over anything. I think I did a pretty good job of covering everything that needed to be covered. And like, for example, both my daughters know exactly what to do in case of, which that was important to me, and
No salt and pepper shaker disputes, huh?
Yeah, not and especially the salt and pepper shakers too, make sure they know where those go. So, but no, seriously, it's I think it's really good to think about that no matter what age that you are, because God forbid anything could happen, no matter how young or how old you are, with it. And some people may think, as I talk to a lot of clients, is that, well, I don't need this or I don't need that. And I'm like, but what if something was to happen and you have a home and you have assets, you have a lot more than you ready for. You don't just have it in retirement. You know, it should be an ongoing process throughout your life. Just the same thing as like investing, you know, throughout your life. It's an ongoing process and it changes consistently. So that's the thing I like about it is like even in a trust, you can constantly change it and update it. It's not, you know, it's not the end of the world. It's not a big deal once you have it.
It's a living document.
Yeah. So cool. What did we cover everything that you wanted to cover, Tim? Tonight?
Yeah. I probably even more than what my biggest thing was to just kind of put some information out there and see if there were any questions and address questions for, because like I said, there's a lot of misconception about what a trust is, what a will is, what it's not, when it can be used, what it's properly used for. And again, sometimes people know, sometimes people don't know, sometimes people believe, oh, my neighbor said this, or I read this on the internet. And so.
And I can speak with experience. Taking a home through probate, you know, as many clients that I deal with when they're getting ready to sell their homes, or God forbid, you know, their parents have passed, and what it is, I mean, they think I have plenty of examples where I had a client goes, well, I have a will and we can sell it. No, sorry, a will is not good for real property. You're going to have to go through the probate process, and then all of a sudden it slows down everything in order to get everything in line. That's why I feel so strongly about the subject, is that if you take the extra steps now, it just makes life easier, and it's cheaper in the long run instead of going through the probate process. A lot cheaper. Probate is the most expensive option when you do nothing.
And just to kind of piggyback on that, Oakland County has now allowed us to walk in. Oakland County Probate Court has allowed us to walk in and file, which speeds up the process, because it's not uncommon for me to get a phone call. Hey, we're hoping to close here next week, and we need to open up a probate estate. Oakland, I can do that. Wayne County, and there was a lady I was talking to today with her mom died, and there's a property down in Wayne County where they are under contract and they're looking to close sooner rather than later. I said, Wayne County's still remote. We're at the mercy of them processing it. And Wayne County on their best day is not the most efficient court to be in. I had one last summer where we waited 7 weeks for it to be processed. And nobody wants to hear that. And that's dicey there.
Awesome. How about anybody else? Anyone else have any questions?
Okay.
I guess you did a good job, Tim.
Thank you for having me. Thank you for everybody's attention on this. I know that trusts at 7 o'clock at night is not the most tantalizing experience.
No, I'm just kidding.
But I hope that you at least it got something that you can take away.
Yeah. And I'll make sure if you guys if you want to put your information, Tim, in the chat real quick, you know, just so people have it. If you want to just type it in real quick while you're doing that, just in case anybody would like some follow-up. Tim is really good about Tim's really good about getting things initiated and started and answering any questions that you may have. So he's just usually a phone call away for it. He's been a great advocate to our vendor list, you know, for real estate. Does a great job. So with that said, like I promised, I was going to hand out like a little gift card, just to say thank you for coming on. I'm going to start doing that throughout the whole year. This is also recorded. So I'm going to be sending out a follow-up email to all of our client database, as well as in YouTube, getting it all set up. There's Tim's information right there. And so got the background in here is probably hard to tell, but I do have a bowl here. So that I'm doing. So all right. So with that said, let's see. Well, who do we have? Suhey and Michael Dunn, you are the recipients of the $50 gift card.
Awesome. See, I told you.
$50 Visa gift card that we'll be sending out in the mail tomorrow.
Awesome. Thank you. And
So
thank
thank
you
you.
for all the information.
Thank you for being a part of it. Hopefully it was beneficial for everybody. And I wouldn't be remiss if I always ask, thank you for being a part of it. Thank you for being my friends and clients. I can't tell you how much I appreciate all of you for helping us thrive in our business. And of course, I'm definitely never too busy for your referrals. So if you know anyone, just give me a call and I promise to take excellent care of them. Okay. So thank you very much, everyone. I really appreciate it.